This is Hakimi Abdul-Jabbar live on podcast. Title of this talk is How ISIS Has Changed International Law. 2 years ago, virtually no one had heard of the Islamic State of Iraq and Syria, known by its acronym ISIS. Since then, ISIS has emerged as one of the most wealthy, powerful, and dangerous terrorist organizations that has ever existed. ISIS now possesses more than $2 billion in stolen cash, thousands of captured tanks and bombs, as well as lucrative oil wells and refineries in large parts of Syria and Iraq that it has taken over. In these areas, the United Nations Human Rights Council in its reports have determined that ISIS is committing ongoing genocide against Christians, Muslims of the Shiite sect, and Yazidis. Beheadings, burning people alive, mass rapes. These are the methodologies of ISIS terrorism. ISIS is based upon the Islamist ideology and theology. The head of ISIS, Abu Bakr al-Baghdadi, is a trained Islamist in the ideology of Islamism, who is a holder of a bachelor's, master's, and doctorate degree in Islamic studies from the Islamic University of Baghdad. The ISIS threat is not only confined to the Middle East. In October of 2015, they bombed a Russian airliner. In November, they attacked Paris. ISIS terrorists bombed the Brussels airport and a key train station. They have killed many children, many innocent children. The attacks of ISIS have left hundreds and hundreds of Westerners dead and over thousands injured. Any city in the world could be the target of the next ISIS terrorism. The events unfolding in Syria are bringing about a major change in international law. There is a major need to respond with force to ISIS, which has redefined this use of self-defense in international law to include attacking a non-state threat in another country. Since August 2014, the United States of America has carried out more than 20,000 bombings and cruise missile attacks against ISIS targets in Iraq and Syria. Iraq consented to their strikes in its territory, but Syria didn't. And Russia blocked the United Nations Security Council from authorizing force against ISIS in Syria. For 2 years, the US was virtually alone in its efforts. Russia, China, and even the US's staunchest ally, the United Kingdom, felt that the US could not justify its bombings under existing international law. The United States government initially invoked several different legal arguments in arenas such as the UN to justify airstrikes against ISIS in Syria. These included the right of humanitarian intervention, controversial without a United Nations Security Council resolution, the right to use force in a failed state, equally as controversial, and the right of hot pursuit, usually used to justify pursuing ships in international waters, but has also been used in the pursuit of terrorists in the Mozambique territory, as stated in many public international law textbooks and casebooks. However, none of these had a solid grounding in international law that would have justified violation of another country's sovereign territory. The use of force in self-defense against terrorists within another sovereign nation had not been viewed as lawful unless the terrorist organization was under the effective control of that nation. This is a position that had been repeatedly reaffirmed by the International Court of Justice. The United States argued that such force can be legally justified where a governing authority is unable or unwilling to suppress the threat operating. That particular view has not been initially accepted by Russia, China, or the United Kingdom. However, the position of the permanent members of the United Nations Security Council, the UNSC, changed in the aftermath of the ISIS attacks on the Russian jetliner on the Paris Stadium and Theatre, which led to the unanimous adoption of a UNSC resolution calling on nations to use all necessary measures to fight ISIS in Syria. The new UNSC Resolution 2249, adopted in November 2015, it clearly does not endorse a particular legal justification. Despite its ambiguity, it will likely be viewed as confirming that use of force in self-defense is now permissible against non-state actors such as terrorists when the territorial state is unable to suppress the threat that they pose. In the aftermath of the adoption of the UNSC resolution, Russia and the United Kingdom joined the US in bombing ISIS targets in Syria. Today, more than 66 nations, as of today, 66 nations are united to fight ISIS. Implications for the future. The implication of this newly accepted change in the international law of self-defense is that any nation can now lawfully use force against deadly non-state actors in another country if the government of that country is unable or unwilling to suppress the threat within its borders. Nevertheless, the use of force under this new approach is still subject to limits imposed by what is known as customary international law, CIL, or the practices that the international community of states customarily follow from a sense of legal obligation. Specifically, only an armed attack can trigger the right to use force in self-defense. Mass terrorist attacks that result in hundreds of deaths meet that threshold. Smaller scale incidents will not. The use of force must be targeted against a terrorist organization and not against the nation where the terrorist group exists or that nation's military, unless the nation is shown to be effectively in control of the offending group. Military action must still meet the international principles of necessity, proportionality, and discrimination. While this new authority will certainly prove useful against ISIS, there is a likelihood that it will ultimately be used against a much broader group of threats. Such threats could include a variety of terrorist groups, as well as rebels, pirates, or drug cartels. The number of candidates of such self-defense action is quite large. With so many potential targets in so many countries, one must ask whether the possibility of abuse will ultimately outweigh the benefits of weakening ISIS.